Okay, everybody, this is a different kind of sight. You're seeing it at the highest court here, listening to oral arguments. It's not a trial. This is an appeals process. And I want to bring in our very special guest, juvenile judge and trial attorney Ashley Willcott, to talk a little bit more about this. Ashley, what can we expect today in these oral arguments? And I don't know if a lot of our viewers have been able to see something like this before.
Right. So this is amazing. So first of all, just in terms of the logistics, Jesse, each side, the prosecution and the defense, have the opportunity to make oral argument based on briefs that have already been submitted. And then obviously justices, all 7 of them, can ask questions whenever they would like to ask questions to get information. The next step in that is that I want to point out is the freedom of speech argument, right? So the defense is going to argue that this violated her freedom to speech because she was convicted basically on words that she said or texted.
But the counter argument to that is if it wasn't for her, he would probably be alive today, right?
Absolutely. But this is a fascinating case because it is the first instance where a manslaughter conviction has been based on words alone.
Are you concerned that if this is upheld, okay, and then we have a situation where someone could be found guilty of involuntary manslaughter by words alone or text messages, even when they're not even present with the victim, that this could create a dangerous precedent?
It might create a dangerous precedent. I mean, I think we all agree it's pretty atrocious to think that she texted and said, get back in the car, basically kill yourself, right? Like, that's horrible on all kinds of levels. But the thing that I think is central to this argument is whether or not she had any responsibility to actually assist him or help him or report it. And if she did not, was that a crime? I think that's the crux of the issue in this case.
All right, let's go back live into that courtroom right now. Okay, this is the beginning part of some oral arguments right now in the Michelle Carter appeals case. This is fascinating to watch. We don't always get to see these appeal cases, so I want to bring on right now Ashley Willcott to talk about this. Ashley, what have we made so far from the defense's argument? Remember, they're the one who brought this appeal, so they go first. So what do we think about how they're doing so far, and what's the arguments they're making?
So first of all, the argument they're making right now is the sufficiency of evidence. And the defense is saying the prosecution did not have sufficient evidence because it was based only on texts. There was no collaboration. That's all the evidence that they have. There's no way to say then what the context is and where he was and what he was doing when she said get back into the truck. And that's their argument at this point, sufficiency of evidence. Now, I think they're going to move to a constitutional argument, but right now that's the focus of this argument. I think he's fielding the questions really well, and he knows the cases in Massachusetts. He knows what the law is, so he's able to respond to the justices, which is really important.
It's a tough job for an attorney in this kind of context. That should be noted for all of our viewers that during these oral arguments, the judges basically act like devil's advocates and ask all those counter questions that you want to have to understand the argument. We will take a quick break. When we come back, we will be back live in Michelle Carter. Welcome back, everybody. We have an exciting day here on the program because we are live in the Massachusetts High Court to determine what will ultimately happen with Michelle Carter. You might remember this teenager was found guilty of involuntary manslaughter for basically convincing her boyfriend to commit suicide. Now, this concept of finding someone guilty of involuntary manslaughter when they weren't even present with the victim, and it was all through a series of words and communications, is a very novel issue and a very novel decision. So this was brought up on appeal. There's oral arguments happening right now to determine what ultimately the highest court in Massachusetts will do. I'm back here with Ashley Willcott. Now, Ashley, let's talk a little bit about how this is going to work. We see the defense, who gets to go first because they brought this appeal, arguing why this conviction should be thrown out. But what is the state going to argue? What is their strongest argument moving forward?
I think their strongest argument, obviously, is that the text messages in and of themselves were enough to show the intent and that she actually failed to assist him and actually encouraged him to commit suicide, amounting in manslaughter. Those are the arguments they're going to have to make. Now, the freedom of speech piece and whether or not it violated her freedom of speech, they're going to have to argue that she had a responsibility, a duty, and she failed to fulfill that duty, and therefore the constitutional issue doesn't come into play. At least that's what I think they're going to argue.
From a practical point of view, she was sentenced to 15 months in jail, but she's remained free while she pursues her appeal. So How does this really work? When would we get a decision from the Massachusetts Judicial Supreme Court? When would we get that decision? How would it work? Like right after today, she goes to prison. Does it wait for the decision? How does this work?
Yeah, those are great questions. So in this state, they have 130 days to issue a written opinion. So that's a little more than 4 months or 4 months, which means I don't think we should expect an opinion until 2019. So once they get that opinion published, then we know, based on what they find on the sufficiency of evidence in the constitutional argument, whether it is either going to be denied the appeal, it could be vacated and remanded back for a new trial, or it could be remanded for a new trial, or in the alternative, her sentence could be vacated and it could be over. So depending on what those findings are, affects the next steps.
Pretty interesting. I mean, this can go any which way, and we are covering this live. This is something we don't always get to do here on Law and Crime, these oral arguments. Let's go back live into that courtroom right now. All right, sorry about that, folks. We're going to jump back into that courtroom in a minute. Just want to bring back on Ashley Willcott to talk more about this as we wait for the feed to get fixed up. Ashley, what were we getting into there? The idea of that, was she really the responsible cause, the actual cause for Conrad Roy's death? Is that what we're getting at?
Well, let me just first say this is fascinating to me. I love that Law and Crime is covering this. And this specific argument he's making right now is, look, the trial judge basically said, hey, she could have called 911. So the trial judge was focused on she had a duty and she failed to fulfill the duty to help him, right, versus what could have been an argument of she coerced him into the truck. And so he's now distinguishing those two things, the coercion, which the judge never focused on, versus the duty, responsibility to actually help him, which he's saying, look, we don't know what would have happened to him anyways. And this is the legal part. I love our justice system. The legal part he's arguing is, Jesse, I get excited about this stuff, is that specifically now I lost my train of thought.
That's okay. That's okay. You'll think about it again. We're gonna jump live in a minute, but we have to take a quick break. So Ashley, when I get back, I want to ask you what other ways she might have been prosecuted here if it wasn't involuntary manslaughter. What other avenues could they have gone, and was that the good decision going involuntary manslaughter? We'll take a quick break, but when we come back, we'll be live. Stay tuned here on Law and Crime. Okay, everybody, so sorry the feed keeps cutting out. We'll jump back in a second, but it's okay because we're here with Ashley Willcott to talk more about it. This is really a really novel issue. We're talking about involuntary manslaughter for this behavior. What else could they have charged her with? I mean, that might have been more of a less controversial stance. So if you're having someone, if you're encouraging someone to take their own life, what would have another option have been?
Well, I think that they could have looked at, obviously, the criminal statute in that state, but coercion, right? They could have also argued a failure to protect, perhaps, or endangerment, any of those criminal charges. I think in this case, though, the prosecution, Jesse, decided to really, and not to make it seem trite, but go big or go home. They went for the highest possible charge that they believed they could prove beyond a reasonable doubt.
But the question is, who's ultimately responsible? So you're hearing this back and forth about he's the one who took his own life. And yes, she encouraged, but really, was she the final straw? I mean, that's a big argument to make. We cover a lot of cases here who we know somebody would be alive if someone, the defendant didn't shoot that person or didn't stab that person. But here, he was the one who took the act. What do you think about that argument?
Well, that's the leap, right? That she wasn't even there. She didn't do anything to him directly, shoot him, stab him, anything else. And so I think it's a very big leap to say she simply texted him all of these messages and she was therefore responsible for his death. The other piece of that it's important is to recognize that this state does not have a statute that criminalizes assisting suicide. So there is no law that says it's a crime to do that. So I think that I really think that on appeal, the defense has a really good legal argument to be successful.
Would you ever be nervous that if this got upheld, then you have a situation where people online who are bullies and trolls, they might be held liable for what people ultimately do to themselves?
Oh, 100%. I think you've just hit the nail on the head. This can set precedent that will open a floodgate, in my opinion, of cases that are then going to be charged and tried because of someone's words.
Right. It's a little scary precedent. We're going to have to see. Now, I think what we're going to do is we're going to take a quick break. We might not go back to Michelle Carter just yet. We might play it at midday. We'll let you know at the upside of this break. But stay tuned here on Law and Crime because we're also covering two really big trials, and we'll talk more about it after the break. Stay tuned. All right, we're listening to this alleged confession by the defendant to his cousin back here with Ashley Willcott. That's never good. That's never good, Ashley, right? When you get a defendant not only confessing, but confessing right around the time of the crime and to a family member.
Right. That's never good. But you can see what defense is going to try to argue is that there was no way for him to know, the person testifying, the cousin, if the defendant was being serious, was joking, was making it up, was lying. And so they're going to attack, obviously, the veracity of the statement. When the jury hears that, do they have that uh-oh moment and be like, got it, okay? And then is it hard to convince them otherwise about it once it's first introduced? I think it is. You know, it depends on how effective they are. But I think it's very powerful testimony for a jury to hear, oh, he told a cousin he did it. I guess my question is, why would he make it up? Why would he be joking about that? Right. I think that's going to be prosecution's argument, especially in closing, right? When they have this evidence, they can argue to the jury. Why would someone make it up? Why would he be joking about it? But we have to see how defense is going to cross-examine. Well, we will play that in a little bit, but we have some more of David Rangel on the stand. This is one of the most exciting witnesses we've seen yesterday in this case, and we will be live in that courtroom today. So let's play a little bit more of his testimony. Okay, that was a really good exchange, and I want to talk about it with Ashley right now. So what he's talking about is the actions, the behavior of Al Marquez, who is the El Paso Police Department investigator, and he's basically claiming that while he didn't like my testimony, my statements that I was making to him, and he was forcing me to say things that maybe weren't true and coercing me one way or another. And you hear the prosecutor saying, well, when did you ever go back to correct that? And I think that was a good point, but I'm curious your perspective on it. It was a great point, but then you notice he said, I didn't go back because basically I was intimidated. I was uncomfortable. I didn't want to go back and see this person. So he also had a very valid, fair response based on his testimony. You know, a lot of times we're cynical here. We always look for that someone's not telling the truth, someone's hiding something. But at the end of the day, people are human beings, and everyone has a different reaction. Some situations can be uncomfortable or awkward. Here, we keep seeing this evidence that's being put forward that, you know, the investigators were trying to get the story that they wanted. Do you see that a lot? Well, no, I don't. I think, again, this is an outlier. I think investigators are specially trained to ask questions in a way to get the information from a person, but I don't think that it's typical that it goes up on appeal previously and that the confessions are all thrown out because of the tactics and intimidation. Well, one thing we know that the jury doesn't know is this Marquez individual, this is the confession that was ultimately thrown out. So the one that we're talking about that Villegas made that resulted in this third trial because of this improper confession was made to this investigator. That's right. And it's a hard thing. You and I have talked about, I think yesterday, it's a very hard thing on an appeal to win it for those grounds. But keep in mind that the defendant was only 16 at the time that confession was obtained, and that age makes a difference, too. It really does make a difference. So what we're going to do is we're going to take a quick break. Much more to discuss here in this case, and we will discuss Jason Van Dyke as well. Okay, so this back and forth right now is heated. Ashley, it's kind of funny to see this in the sense that the prosecution really wanted this witness. Hey, we got a guy who has the defendant, says the defendant confessed him to committing the crime. But now let's yell at him a bunch because we don't like that he's saying the investigators coerced his own statement. Right. So this is what happens when you're in trial and you have a witness who all of a sudden you have to go up against your own witness and try to destroy what they've said to make it come back to your side and look good. So I'm not surprised in this case because as soon as he says, look, they were coercing me. I didn't want to go back to them. I wasn't comfortable with them. Prosecution has to rehabilitate their side of the case with this witness. Do you think what he's saying has validity? I mean, again, what you and I know, what the jurors don't know, is that this is his third time on trial, and his last conviction was thrown out because of police pressure to get him to confess. So this seems like what Mr. Rangel is saying could possibly be true. Absolutely. I think it has validity, but I also think more importantly, the jury needs to determine, is this witness credible? Do they actually believe him in this story? I find watching him, he is credible. His eyes to me look kind of red and a little teary, and he seems very genuine in his testimony.
Yeah, I have no idea the relationship between these cousins, what if it's good or it's bad, but you got to imagine going on the stand saying that my cousin confessed to murder is a difficult thing for him to say. And yes, he's going to talk a little bit later about how it was just a joke, but he's also knows what the impact of his statement could be.
Absolutely. And he knows, too, that he gave his statement at the time. So there is a written statement with all of the information. So while he can say, I can't recall now, they can use that statement, as they've already done, to say, yes, but at the time you said this.
Let's play a little bit more of his testimony. Again, this is the Daniel Villegas case. If anybody's just joining us, third time this guy's on trial. It is a really, really unique case, and this is his cousin. Let's keep going. That's the defendant's cousin saying, I thought he was just joking when he told me that he committed these crimes, he committed these murders. Back here with Ashley Willcott to talk more about it. So we're going to conclude our discussion on Villegas. I'm curious, he obviously believes that, the defendant believes that he has enough to convince this jury that he didn't commit these crimes because he was offered a plea deal and chose not to take it.
I'm not surprised he didn't take that plea deal because, remember, this is his third trial. The confessions were already thrown out and they cannot be used. There was some phone calls in jail. That was actually thrown out as well and cannot be used. So I don't think he has an incentive to accept a plea in this case. I'd go for it, too, because without that evidence, they may or may not be able to prove it beyond a reasonable doubt.
What we've seen so far is some witnesses testifying to the fact that, okay, we were there at the shooting, but we didn't see who did it. Then you have this cousin who comes forward and says, hey, he confessed to me. But I wonder, without more, if this is enough to convict. I mean, yes, the case is still going to be going on. We're going to see if there's any forensic evidence. But I wonder if they have as strong a case as they want after 25 years.
Well, I think after 25 years and given the evidence that they have, I think that there may be some good argument that there's reasonable doubt. Did he really do it? Now, having said that, there was one witness who actually described the ping, the sound of the gun, and the flash because he actually witnessed the two being shot in the car. So I don't know. On this one, I really don't have a good sense of what's going to happen in this case.
And we can't forget that investigations back in 1993 and the way evidence was collected and the way things were interviewed is very different than we have in 2018, and we think that might be a factor. But we will be live in that courtroom today, but we're also going to be live in Jason Van Dyke. We'll talk more about it right after this. Stay tuned. Okay, so you're listening to the prosecution and the defense's opening statements, two competing narratives. Which way will the jury ultimately go? This trial's been lasting quite some time. Everybody's watching it. We've been following it gavel to gavel. I want to bring back in juvenile judge and trial attorney Ashley Willcott to get her perspective on this latest development that if the jury now has the option to convict him of the lesser charge of second-degree murder and not just first-degree murder, we might be talking about a whole new ballgame.
Absolutely, because that directly affects what his likely sentence would be. So the difference between first-degree and second-degree murder in the state of Illinois is going to be whether or not there are any mitigating factors that the jury finds existed. So, for instance, you already mentioned if there was an unreasonable belief or if he thought that he was protected under the law, for instance. So that may be the way that they determine second-degree murder is more appropriate in this particular case.
That makes sense based upon his testimony and what we've heard. So he thought what he was doing was justified. He thought he was acting in the proper capacity as an officer, but after looking at the evidence, it was an unreasonable belief. I mean, that doesn't seem so far of a stretch.
No, it doesn't. So I do think it's smart to include as a prosecution this lesser included offense because I think the evidence might support that depending on the jury's decision.
I wonder what the defense will ultimately say in their closing argument now to combat that.
Yeah, I don't know. It's going to be interesting to see. I think they're still going to say that in his mind, right, writing down the language of the statute, reasonable use of force by him, that it was his perception, only important is what was in his mind, and that existed.
And maybe they'll talk a little bit more about their own use of force expert, what police recruits are taught, and maybe that he did act in the correct capacity. That'll be more of a tougher argument, but we'll see. Let's play a little bit of the defendant himself, because he took the stand, which is something pretty incredible you don't always see. So this is Jason Van Dyke explaining in his own words what happened when he shot Laquan McDonald. Okay, Ashley, how is the jury going to reconcile this? You know, we do have to take into account what was going on in the defendant's mind, but at the same time, you have all these other witnesses who are coming forward and really didn't see the threat that he saw.
Well, I think if you look at the video that's been shown, that you see the police officers are in different places or positions related to the defendant. And so one way the jury might reconcile these two pieces of testimony is that he, in fact, was in a different place and saw the defendant differently than the officer who just testified. So maybe they're both accurate descriptions of the incident, but two different perspectives based on where they were and what they saw.
Yeah, because you could argue that that video, while shows a lot, maybe doesn't show everything. I'm curious, we talked about it a little bit before with the defense. When they present their closing argument, yes, they're going to say what was going on in the mind of their client, but are they also going to say, look, his shooting was justified. Let's talk about this use of force expert. Let's talk about how recruits are taught to put down a suspect when he's carrying a weapon, even if there's nobody else in the area, you know, a fleeing felon. I mean, are these things that you think the defense is ultimately going to argue?
I think they are, absolutely. I think they have to. I think the jury has these questions in their minds, and a good defense is going to know we better argue it and mention it, because if we don't, the jury's not going to, you know, they're going to be really speculating. So I think they're going to have to argue all of those things. And he testified, and then you had the expert who said 1.5 seconds to 1.7 seconds to get from where he was to Van Dyke with the knife, which is enough time that he could have, theoretically, if you believe that expert, stabbed him.
Speaking of seconds, the prosecution's very quick to say that Van Dyke had 6 seconds to think about what he was going to do, and in that determination, he ultimately made the wrong decision. That's what the prosecution will say. Now, here's what we are going to do. We are going to take a quick break. When we come back, there is a lot more to discuss in these cases, and hopefully we will be live in Van Dyke very soon. Stay tuned here on Law&Crime. Okay, everybody was watching the defendant testify. I mean, it really was a thing to see. I'm back here with Ashley Willcott to dissect it. So, Ashley, do you think he's credible? Yes, he's showing emotion. Yes, there at one point he's staring straight-eyed, not even blinking. What seems to be he's recalling the story from his memory. But I'm curious, you have a lot of experience with this. Does this seem like a credible witness?
Credible witness, even though you just described the things and how he actually appears. I question the sincerity of his testimony. I find him personally to be somewhat pathetic in his presentation, and I feel like he's now had an opportunity to hear everything, and he's kind of thinking to match what he's saying to what the evidence is. So that's just my personal opinion, but I don't find him super credible. I do feel sorry for him. I don't think he went out and said, I'm going to murder this man, but I think he did it unreasonably. So
the tears, the emotion is not so much for Laquan McDonald, but for his own situation?
That's what I wonder. Is it because he got caught and he's facing these charges and it's a highly emotional time for him? And I'm sure he feels bad he shot someone. I'm not meaning to suggest that he feels good about the fact he died.
Yeah, I mean, that's the question. We don't really know what's going on in his head, but we're trying to get an understanding of what was in his mind in the time in question. All right, everybody, I am getting an update right now that we are live in the Jason Van Dyke courtroom, so let's go live into Illinois. It looks like a packed courtroom. Let's go. That's the prosecution delivering their closing argument right there and explaining the differences between first-degree and second-degree murder, 2 options for the jury to consider. I have to, unfortunately, sign off my guest, Ashley Willcott, right now. And now, Ashley, what do you think about the prosecutor? How's she doing so far in this closing argument?
I think she started strong because she started talking about the emotional aspect, that this defendant's never going to be able to walk again, do anything again because he's been killed. This is not the wild, wild west. I think then she also made a solid argument that this defendant knew when he stepped out of the car that he was going to shoot this man. That was powerful. That
was a really powerful point. Ashley, thank you so much. We have to go to a quick break, but we can't wait to get her back.